Hey, welcome back. Glad you're here for this one, because this is the kind of story that gets one news cycle and then quietly disappears, and it really shouldn't, because what just happened to the President of the United States doesn't happen to presidents. Not like this. Not with this little room left to maneuver, so let's just get straight into it, because the headline undersells what actually occurred here. On June 29th, 2026, the Supreme Court of the United States looked at Donald Trump's final appeal, his last available legal door, and it simply declined to open it. No hearing, no written opinion, no noted dissent from a single justice, including the three Trump appointed himself. 9 judges. 0 disagreement. That is, in legal terms, about as close to silence as the court gets, and silence from the Supreme Court is not neutral. Silence means the lower rulings stand exactly as they were. It means the fight is over. And the fight, in case the details have blurred together over 4 years of headlines, was this. A Manhattan jury found in 2023 that Trump sexually abused writer E. Jean Carroll in a department store dressing room in the mid-1990s, and separately defamed her in 2022 when he publicly called her claims a hoax. The jury ordered him to pay $5 million. He appealed. He lost. He appealed again to the Federal Circuit Court. He lost again. He asked the Supreme Court, the highest authority in the American legal system, to step in and save him. And on Monday, they said no. Here's where it gets interesting, and where most of the coverage stopped short. Because losing an appeal is one thing. What happened in the 72 hours afterward is the part that actually tells you something about how this ends. E. Jean Carroll's legal team didn't wait. The very next day, they filed with the federal court demanding immediate release of the funds. Not $5 million anymore, but $5.8 million, because the original judgment had been sitting in a court-controlled escrow account since 2023, quietly accruing nearly $800,000 in interest, while Trump's legal team worked through every available delay. Think about that structure for a second, because it's actually the most important mechanical detail in this whole story. Trump didn't get to simply say, "I'll pay when the appeals run out." To stay execution of the judgment while he appealed, he had to put the full amount into an account the court controlled, which means the money has been sitting there, untouched for years, waiting for exactly this moment. So when people say Trump just paid E. Jean Carroll $5 million, that's not quite precise. And precision matters here. What actually happened is the last legal barrier preventing the release of money that was already sitting in escrow just got removed. Carroll's attorney, Roberta Kaplan, said it plainly in the court filing. It is time for him to pay Carroll. And within minutes of the Supreme Court's decision, according to that same filing, Trump's own lawyers were already on the phone with Carroll's team, not to concede, but to ask for one more delay, so the president could explore petitioning the Supreme Court to reconsider its own rejection, a request that, according to Carroll's lawyers, is legally almost certain to fail. Judge Lewis Kaplan, who has presided over this case for years, gave Trump's team until July 7th to respond. So as of this recording, the money is not yet in Carroll's hands. It's one procedural step away. Now, let's talk about the reaction, because it tells you something too. Trump posted to Truth Social, calling it a fake case brought by a woman he never met, and said he would continue fighting what he called weaponized lawfare. That's not a new line. It's the same framing he's used since 2019. But here's the long-short version of where that argument now stands. The sexual abuse and defamation claims were tested twice in front of 2 separate New York juries. Both juries ruled against him. A federal appeals court reviewed the trial procedures, including his objection to jurors hearing from other women who've accused him of misconduct, and to the Access Hollywood tape being played as evidence, and upheld the verdict anyway, finding those objections weren't enough to overturn the outcome. And now, the Supreme Court has declined to even look at it. 4 separate legal bodies, 0 reversals. At some point, witch hunt stops functioning as a legal argument and starts functioning as a talking point for an audience that was never going to be persuaded by the verdict in the first place. And that's worth sitting with, because it's arguably the more important story than the dollar figure. Because here's the part that actually matters for the country, not just for Trump personally. This $5.8 million figure is the smaller of the 2 judgments. There is a second case, $83.3 million, awarded by a different Manhattan jury in 2024, for a separate set of defamatory statements Trump made about Carroll while he was sitting in the Oval Office during his first term. That case is still on appeal, and it hasn't reached the Supreme Court yet. But the argument Trump's legal team is building for it is genuinely significant, because this time, it isn't just the trial was unfair. This time, they're arguing presidential immunity, that statements a sitting president makes, even personally defamatory ones about a private citizen, should be shielded from civil liability simply because he made them from the office. Think about what that argument actually asks the courts to establish as precedent. Not, did Trump defame this specific woman? That's already settled twice over. The live question is, can a president say almost anything about a private citizen while in office and be functionally untouchable for it, simply by virtue of the title? That is a question that outlives this specific case, this specific president, and honestly, this specific decade. Whoever holds that office next inherits whatever boundary line gets drawn here. Let's put the numbers in a wider frame for a second, because on their own, none of these figures mean much without comparison. $5.8 million is, for a person of Trump's reported net worth, a rounding error, uncomfortable, not existential. But layered on top of the $83.3 million judgment still pending, the total potential exposure from this one relationship alone approaches $90 million. That's before legal fees on either side, which in litigation stretching across 7 years and touching 2 presidencies, are themselves almost certainly in the 8 figures. And there's one more detail buried in a July 1st federal financial disclosure report that's easy to miss. The $5 million judgment is now formally listed as a liability on Trump's official government ethics filing, not a rumor, not a tabloid claim. A line item filed with the U.S. Office of Government Ethics, sitting alongside every other disclosed financial obligation of a sitting president. That's about as institutionally undeniable as a legal loss gets. And there's a complicating thread running underneath all of this that deserves its own honest mention, because the full picture only makes sense with it included. The Department of Justice has reportedly opened a criminal investigation into whether Carroll herself committed perjury, specifically around testimony related to how her legal fees were funded during the 2 civil trials. That investigation was first reported in May 2026, and it hasn't produced charges. It's worth naming plainly. A sitting president's Justice Department is examining the woman who successfully sued him, while simultaneously that same president is legally obligated to pay her millions of dollars for the underlying conduct the DOJ isn't investigating. Whatever you make of that timing, it's not a detail a serious account of this story should leave out. So, where does this actually land? The $5.8 million question resolves itself within days, maybe hours of this video going up. Judge Kaplan has already fast-tracked it, and legal experts are near unanimous that Trump's request for the Supreme Court to reconsider its own unanimous dissent-free rejection is not going anywhere. That part of the story is basically finished. What isn't finished is the $83 million case and the immunity argument sitting inside it, because that ruling, whichever way it eventually breaks, will do something this smaller case never could. It will tell every future occupant of the Oval Office, and every American they might defame from it, exactly how much legal shelter that office actually provides once the cameras are off and the statement is personal rather than official. That's the version of this story that outlasts the news cycle. Everything else, the Truth Social post, the delay request, the $5.8 million finally clearing escrow. That's just the visible part. The real outcome is still being written in a courtroom most people have already stopped watching. That's Fenn for Borderlines. Analysis from the edge. If you think stories like this deserve more than a headline, you know what to do.